These steps are very important to understand the concept of money laundering, but one may note that these steps are nowhere to be found under the PMLA, nowhere to be mentioned under the PMLA. Hence, the question arises as to what is the PMLA and what is the scheme of the Act. The Act has 10 chapters having 75 sections and one schedule. Schedule is what I had just put on screen. Schedule contains all the prohibitions, all the offenses which are prohibited, which would constitute a scheduled offense. And from the generation, money generated out of that scheduled offense would be your proceeds of crime. So forget about the offense, but the money which is being generated is your subject matter of money laundering. How I read the law is that I have divided the law, these 75 sections, into three bifurcations. Three bifurcations. First, I would say is the reporting obligations, which are also available in foreign countries, in foreign jurisdictions with foreign authorities. And Chapter 4 from 11A to Section 15, the obligations of banking companies, financial institutions, and intermediaries. So the first is reporting. Second is your attachment and confiscation. And third is the criminal law of prosecution that would ensue once a person is reasonably suspected of money laundering. My friends, my seniors, my colleagues, the history of law, as the law came out in 2003, it was made applicable from 1st July 2005. The first amendment was made in 2009, where many offenses were added in the schedule. The second amendment was brought later on in 2012, which came into effect from 15th of February 2013. Many offenses were again added in the schedule, so on and so forth. Certain additions, deductions in sections were made. And amendments have been made consequently from the year 16, 17, 18, 19, and so on. And even till today, there are amendments which come forward. And we tend to ask ourselves, I remember in May and in June, more than the calls which I got from my clients were calls which I got from CAs, CSS, and CWAs when that notification came out, and a huge hue and cry was created in the society that CAs have also been brought within the ambit of PMLA. CSS have also been brought within the ambit of PMLA. CWAs have been brought within the ambit of PMLA. And people were going berserk. I will give a detailed speech and I will give my view on that, a detailed view on that. But that is only for reporting purposes. There is no distinction under the PMLA. Anybody from any profession, from any strata of the society, having any post in the government can be brought within the ambit of PMLA, and everybody is equal. So please forget that there is one specific person who is brought within the ambit. Everybody who may be a part of money laundering, and be a part of money laundering is what I will deal further. And it is of a very wide amplitude, of a very wide scope. But before that, what are the important principles of proceedings under the PMLA Act? I worked with the ED for a while, for about 6 months. So seeing how the department works on the inside, how the prosecutors work, having had the experience and the privilege of working on both sides, I would say, and a lot of prosecutors from the side of ED also say that PMLA starts where ordinary criminal law stops. What does that mean? In an ordinary criminal law, the offense would be investigated by police, by CBI, by other authorities. The statement given to them would not be admissible. The provisions of bail are straightforward, unlike PMLA, where if one reads the provision of bail, he will seek to understand that the threshold of law to seek bail is almost, if not completely, it is almost equivalent to proving to the court and assisting the court to decide that the person is not guilty of the offense of money laundering. That is what you have to prove before the court while seeking bail in a PMLA case. In a criminal law, that does not happen. A statement given to the police is not admissible under law. Section 25 of the Indian Evidence Act. However, a statement given to the ED is on oath, can be and will be used against you. The attachment of property is not only of money launderers, but wide amplitude that even today, if you might be in possession of where I have committed a crime, got some money, given that to Satishji, which Satishji has given to Ratanji for an actual bona fide purpose. The asset of Ratanji might come into attachment under the PMLA. That that is the wide amplitude of the PMLA and the objects of the PMLA. I have taken a lot of time. I've mentioned proceeds of crime. My learned seniors here, Mr. Singhvi Saab, Ratanji, Satishji, my other colleagues mentioned that this is to curb and get that ill-gotten crime, ill-gotten money. That ill-gotten money is called proceeds of crime. And please note, this term proceeds of crime forms the most important definition, if not the most important section, I would say the most important definition, which one must read not once, not twice, but 5 times at the least, to even slightly understand what is the grave implication of this. And then when one may read this term, after understanding this term, when one may read the provisions of the Act, the powers of attachment under Section 5, so on and so forth, adjudication under 8, so on and so forth, one will see that what and how wide the section is. I will attempt to show or to demonstrate the wide amplitude of this section. So section 21U, as my learned friends, I hope my screen is visible. 21U, proceeds of crime, means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So any property derived or obtained directly or indirectly, derived. So I said Ratanji got a property, he derived some property, which is relating to a scheduled offense. You see the wide amplitude. अगर सिर्फ टर्म यहाँ पे होता प्रॉपर्टी डिराइव्ड और obtained directly or indirectly by any person as a result of criminal activity of a scheduled offense, तो वो रिस्ट्रिक्ट हो जाता. आज the term which stays today is any property, कोई भी property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. ये पहला लिम्ब है, where I have given, let's say a crime cheated a bank, got 100 crores with me. My company got NPA. I am abroad. I gave that money to Ratanji. Ratanji invested that money in let's say 5 flats. That money directly is traceable. मैंने crime करा cheating, scheduled offense. पैसा generate करा becomes proceeds of crime. Money given to Ratanji, which he has invested in this act in 5 flats. Direct attachment. This is the first limb as a result of criminal activity relating to a scheduled crime. First limb. Second limb, or the value of such property. Now I know I cheated. I cheated the bank. But when the money came to me, I gave it to 5 people. Some money came back to me. Then I went, gave it to somebody else. आज जब investigation चल रही है PMLA की, then that exact direct POC is not applicable or not found. Then any property derived or obtained as a result of scheduled offense, or the value of such property, और द वैल्यू ऑफ दैट प्रॉपर्टी 100 करोड़ के मेरे हाथ में या मैंने आगे किसी को दिया उनके हाथ में, द प्रॉपर्टी वुड बी क्यूमुलेटिवली अटैच्ड. नाउ द थर्ड लिम्ब, इफ यू टेक दैट मनी आउटसाइड, then any property in India or abroad can be attached. So when one reads this definition and puts his or her mind to the each syllable, to each word, to each connecting word, applies the principles of interpretation of statutes, such as easdom, the principle of easdom generis, one will see or one will fathom the wide amplitude of this section. Now, though the name of the act is Prevention of Money Laundering Act, money को बस नाम दिया गया है money, technically it is the property, and any property of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, can be attached. Today I get a crime, मैंने रॉयल्टी पेमेंट भी कर दी अपनी एक फॉरेन एंटिटी को रॉयल्टी पेमेंट की तरह दिखाते हुए. That would include intangible property of the foreign entity. So one should also understand, as we are all having a background of tax, one can understand what is the interplay of tax, what is the interplay of other laws in this, what is the interplay of fiscal statutes which may come in the PMLA. Ab sab, we all have heard that this law is very draconian. This law is has very sharp and big teeth. I will give you an example of that teeth. One example, one small bite I will show you. How does ED bite you and how does this law bite you? आपने आज आपकी एक प्रॉपर्टी अटैच होती है साहब. आज उस प्रॉपर्टी की वैल्यू, गोल्फ लिंक्स की एक प्रॉपर्टी है, आज उसकी प्रॉपर्टी की वैल्यू है लेट से 100 करोड़, जो आज की डेट में गोल्फ लिंक्स की प्रॉपर्टी है. एंड दिस इज वन ऑफ माय क्लाइंट्स ओनली आई एम talking about. A property worth 100 crores today will be attached at its value, which is the fair market value of that property on the day of its acquisition. So साहब, acquisition, I acquired this property for 10 lakh rupees in 1980. और मेरे ऊपर 50 करोड़ की पीओसी का केस है कि यू हैव प्रोसीड्स ऑफ क्राइम टू द ट्यून ऑफ 50 करोड़. My property, which is actually worth 100 crores, would be attached at a value of 10 lakh rupees. One should just stop here and think about the ramifications which one person would have when such actions are taken against them. But having said this, what is money laundering? Money laundering has been defined under Section 3 of the Act, which reads as, whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it to be untainted property shall be guilty of the offense of money laundering. When we read this section for the first time, we feel that it might be a reasonable section. Yeah, so they are getting safeguards such as directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in the process or activity connected with the proceeds of crime. Now, the specific portions of this section which we need to remember is directly or indirectly attempts to indulge, knowingly assists, knowingly is a party, is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, use, projecting, or claiming it to be untainted, shall be guilty of the offense. Now, today, Ratan, this seems to be very fair. But let me pose a question before myself and before the members who are here. Let's assume Ratanji scams a bank today, right? And I am developing a locality, let's say in Delhi outskirts, a gated colony, I may say so.
Hello.
I look for investments. I ask Ratanji or other people in my known circle, I'm looking for investment. Now Ratanji comes to me that, yes, I'll invest in this and I will keep 30% of the, 30% of the investment. 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 30% of this will be mine. Ratanji gives me that money. He gives me 50 crores. Now the bank comes after him. ED comes after him. The bank goes NPA, files a complaint, files an FIR for cheating, so on and so forth. Goes into SARFAESI Act and all the other laws which the banks use for recovery of money. They also file a criminal complaint. They also file an FIR. After that FIR, money laundering proceedings begin. Money laundering proceedings begin by recording something which is called as an ECIR, or an information or an ECIR, case related enforcement case related information report, sorry, ECIR. On that basis of that ECIR, it conducts its investigation, and so on and so forth. Attaches my property. I will come to this example when I get into my attachment, but they start. Today, ED also comes to me. They find the money trail. What is a money trail? Money trail, to explain easily, I would say that take a piece of white paper, take a small ant, dip that ant into ink and drop that ant here. Wherever it walks becomes your, wherever that money goes, take that money as that ant. ED can reach there, and that is tainted money. And wherever it reaches point A person A, point B person B, point C person C. All those people can be bought within the garb of money laundering. So coming back to this section and back to the wide import of the offense of money laundering, Ratanji gives me that money. And today, ED people come to me, they ask me, sir, you are well aware, you know Ratanji from a long time, and this, that, and all that. I claim this. When I tell the ED people, what will I tell the ED people? I will tell the ED people that this is a bona fide arm's length transaction. I am developing this society. For this money, I have given 30% shares to Mr. Ratanji. ED will see my explanation today, and I kid you not, my explanation today will be seen as I am claiming it as untainted property. And when I claim it as untainted property, they are very well within their bounds to show that I may have directly attempted to indulge in an activity or process connected with the proceeds of crime. And I am projecting and claiming it to be as untainted property. And therefore, I am guilty of the offense of money laundering. So one should think as to how, as to the extent, as to the far-reaching extent of PMLA. एक मूवी का डायलॉग है, कानून के हाथ लंबे हैं, लेकिन जो कानून बना है और ईडी के हाथ में दिया है, वो हाथ कानून से भी ज्यादा लंबे बन चुके हैं, is what I would say. This explanation to this section would further corroborate the statement which I just made. And I don't mean to make any offense to any authority or to any officer or to anybody, but these are my own personal views, which I have. My view is further, in my view, corroborated by the explanation which is given under this section, which reads that for the removal of doubts, it is hereby clarified that a person shall be guilty. The word uses shall, one may read. Shall be guilty of the offense of money laundering if the person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more processes, activities connected with the procedure of crime, namely concealment, possession. Concealment, chalo, I agree for a moment. If you're concealing it, so there is a direct attribution. But in possession, how can a person today know that the money which I have, or even as a matter of fact, my clients pay me money, how do I know that that money is not tainted? Can I ask my client today that sir प्लीज आप इस पैसे का सोर्स बताइए मेरे को फीस देने से पहले? माय क्लाइंट विल बी अच्छा ठीक है सर, सोर्स तो मैं आपको देखता हूँ, लेकिन सोर्स के अलावा केस आप मेरा वापस दे दीजिए, मैं केस देख लूंगा सर जहां से करवाना है मेरे को. Or in any manner in a business transaction, can we really go on behind source of source as we do in section 68? When an income tax proceeding of cash deposit is opened under section 68, source and source of source is to be proved. But when just entering into an arm's length business transaction with somebody, can we today go on to the source of source with that person? Is it business? Is that viable? Then acquisition, use and projecting it to be untainted property, claiming it to be untainted property whatsoever. And clause 2, that the process or activity connected with the procedure of crime is a continuing activity and continues till the time that such a person is directly or indirectly enjoying the procedure of crime by its concealment or possession or acquisition or use or projecting it to be untainted. The punishment for money laundering is given in the section 4. It is punishable for a term not less than 3 years, but may extend to 7 years and also be liable to fine. In the schedule which we just saw, scheduled is bifurcated into part A and part B. If the offenses of part A, that 7 years should be read as 10 years. So the offenses in essence, as it exists today, आप 10 years ही मान के चलिए, because in schedule B, in part B, there is only one offense which is under the Customs Act. So technically your offense would be, if you're found guilty, your punishment would be up till 10 years. The proceedings under the PMLA are twinfold, civil and criminal. It is not a new principle. It is rather a principle which we have seen in a lot of fiscal statutes. I would also say income tax. I would also say other fiscal statutes. Because even under income tax, there is a provision for prosecution when there is non-recovery of demand. There is attachment under the second schedule of the Income Tax Act. Just like that, the same methodology is the same thing has been borrowed under the PMLA, and the proceedings under the PMLA are twinfold, civil and criminal. Civil start with attachment and confiscation, forfeiture of property. Your criminal is your criminal trial which go on. Coming to the civil part of it, what we hear for the ED, what we hear about PMLA is seldom the fact that a person is found guilty of the offense of money laundering. Since 2005 till now, there may be only very few cases which we can technically count on our fingers which have attained finality and where the person has been convicted. Apart from that, the cases are pending. The criminal trials would go on and on and on for years and years and years to come. They would have thousands of witnesses. Your complaint would go on for lakhs of pages. Lakhs of pages, I'm not exaggerating, because I've seen and worked on such cases where the complaint is of more than a lakh pages long. But what we hear is in the news is that a person is arrested and property is worth such and such crores are attached. Sir, under the Income Tax Act, today, if a proceedings are to begin, we will first be issued a show cause notice. If it is a scrutiny proceeding normal, then a notice under 143 2 would start the proceedings. If it's a 148 case, then it would be a case of 148A, or if it falls under the exceptions of 148A, then directly under 148, or earlier how it used to be under 153C. Under the GST law, likewise, he would get those show cause notices. But in ED, sir, what makes this law so draconian is the fact that you might not even know that there is an ECIR registered against you where you are an accused or maybe a suspect. Or even if you're not an accused or a suspect, today your property can be attached. You will not receive any show cause notice. You will not receive any notice. One fine morning, you will get up in the morning and you will receive a notice where your property will have been attached already. Or your client will be called for summoning, will be called for a statement. He will receive summons. You will not know that whether your client is an accused or suspect. And you will not even know that today when your client goes to the ED office, he might even be attached, he might even be arrested. These are the far-reaching consequences of PMLA proceedings. So if we read section 5, which is attachment, I will first like to start with how is an attachment made. And my friends, you will, while going through this section, you will find terms which are very familiar, such as reason to believe. But in income tax proceedings, I myself have caused over 70, 80 cases on this concept of reason to believe. But sadly, the state of affairs today is that reason to believe under the PMLA is given a complete go by. And I will also prove it and demonstrate it to you with examples as to how. Section 5 includes attachment. Attachment of a property involved in money laundering, where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reason to believe, which is to be recorded in writing, on the basis of material in his possession, that A, a person is in possession of the proceeds of crime, and B, such proceeds of crime are likely to be concealed, transferred, or dealt with any manner which may result in frustrating any proceeding relating to confiscation of proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. So what one may note is that the reasons to believe are qua two things. Any person is in possession of proceeds of crime, and these proceeds of crime are concealed, transferred, or dealt with any manner which may frustrate in any proceedings relating to confiscation of proceeds of crime under this chapter. Now one may go back to when I said that the definition of proceeds of crime is of grave, wide amplitude. One may see it from here because that definition of proceeds of crime has three. One is direct POC, obtained directly as a result of the scheduled offense, or the value of such property, or when such property is taken abroad, then the value of that property in India. So today I ask myself one question. How can a person have such direct material if he is attached to the second limb of the PMLA, that this is directly attributable, or that directly proceed? Doesn't that discretion of using the second limb and calling that second limb, which is value thereto of the property, as proceeds of crime, giving an unfettered discretion and reducing the threshold of reason to believe for making any attachment? One should ask himself or herself this question. And one may also ask himself or herself this question, that in general parlance or in general principles of law, not since today, but since the 12th century, when the king's rule ended and legal systems were brought into existence, since that time, bigger the crime, more the onus on the person who is accusing one person. And when they take an action, bigger the statutory duty to prove that yes, they are liable to take this action. So henceforth, when we read the definition of proceeds of crime, and when we read it and intermingle it with the powers of attachment, one may say that the term reason to believe, which can be seen as a safeguard, is technically made or technically has been diluted quite a bit by giving this discretion to the authority because of using such widely worded sections. Now, sir, earlier this attachment will be valid for a period of 180 days of this order. So a lot of times we see that an order is passed and, oh wait, I will actually do that in due course when I explain it. Second part, provided that no such order of attachment shall be made unless in relation to a scheduled offense, a report has been forwarded to a magistrate under section 173 of the CRPC, or a complaint has been filed by a person authorized to investigate the offense mentioned in that schedule before a magistrate or court for taking cognizance of that scheduled offense as the case may be. मतलब कि अटैचमेंट तब तक नहीं होगी जब तक 173 में चार्जशीट जाती है आपकी, जब तक आपकी चार्जशीट नहीं तैयार हो जाती या फिर क्रिमिनल कंप्लेंट नहीं दाखिल होती बाय द ऑफिसर हु इज authorized to investigate that scheduled offense, let's say of cheating, let's say of bribery, let's say under the PC Act, let's say by the CBI. जब वो आपको FIR, जब वो आपकी अपनी चार्जशीट या जब वो अपनी क्रिमिनल कंप्लेंट फाइल करते हैं, only after that can you make an attachment. This is the first proviso. Now, very strangely and very surprisingly, there is another proviso to that. And I ask all my learned friends to be very attentive in this next proviso, because this will show how far-reaching ramifications or how wide the powers of the ED are. Provided further that, notwithstanding anything contained in the first proviso, this first proviso, any property of any person may be attached under this section if the director or any other officer not below the rank of deputy director authorized by him for the purpose of this subsection has reason to believe that for such belief to be recorded in writing on the basis of material of this possession, that if such property involved in money laundering is not attached immediately under this chapter, then the non-attachment of the property is likely to frustrate the proceedings under this act. So, जो ये वाली फर्स्ट कंडीशन थी आपकी कि देयर शुड बी अ चार्जशीट और देयर शुड बी अ क्रिमिनल कंप्लेंट इन योर शेड्यूल्ड ऑफेंस वाला केस, तब तक आप अटैचमेंट नहीं कर सकते, हैज बीन टेकन अवे बाय द सेकंड प्रोवाइजो, which is this. So today you don't need a charge sheet. Today you don't need a criminal complaint under a scheduled offense. You only need an FIR. Scheduled offense का FIR हो गया, ED will come, ED will take your attachment. And what is very strange about this is that the second scenario in this is that the condition is that if the officer in his material in this possession has reason to believe that if such property is involved in money laundering is not attached immediately, then the non-attachment of the property is likely to frustrate any proceedings under this act. Sab, I may ask one thing. This was the very condition which was here before point B. And after point B, a proviso had been given as a safeguard. Then how can we bring the same condition as a second proviso to nullify the safeguard given under the first proviso? And with that in mind, one can think or reasonably even imagine the far-reaching consequences which one person may have. Now, sir, when an attachment has been made, that officer would forward this copy of this order along with the material in a sealed cover to the adjudicating authority. This attachment order, as I mentioned, has a validity of 180 days and it shall cease to have effect after the expiry of that period. So, sir, in case your clients or anybody is facing attachment of property, that attachment can be valid only for 180 days. And in case that 180 days are over and the adjudicatory authority under Section 8 has not adjudicated upon it, one should move to the High Court in a writ petition immediately. And a lot of matters are currently pending today before the High Courts and even before the Supreme Court, where this issue is pending over 180 days. But in all likelihood, this provision should be taken as it is, and this 180 day would most likely not be diluted. As if diluted, if it would give unfettered powers to the authority, and the authority then would be able to take any power, and it would have far-reaching consequences. Now, when this attachment is made, a lot of times a question may be asked that will we be able to enjoy this property? The section itself answers this, which is subsection 4, which reads that nothing in this subsection shall prevent any person interested in the enjoyment of the movable property attached in this subsection from such enjoyment. Therefore, if your property is attached, you can keep using it, but you can only not create any third party interests in it, but you may be able to use it. Now, what happens? After this, after the attachment is made, within a period of 30 days from such attachment, the officer will file a OC, which is called a original complaint, to the adjudicating authority. Adjudicating authority is a superior body, which is akin to, you may call it, your appellate authority under the GST or the CIT appeals under the Income Tax Act. But the only difference is CIT appeals and adjudicatory appellate authority ke paas to we would make an appeal. Here, the director himself will file an OC and we would be a defendant in such proceedings. So, sir, this is the first civil power of attachment which is available with the ED, which culminates into an OC, which is sent for adjudication to a superior quasi-judicial body, which is called the adjudicating authority. Now, the second part of civil action which is available with the ED is the action of search, survey, and seizure. The power of survey, we all are very well experienced, and we have extremely senior members here who have rather dealt with actions under the Income Tax Act in a far big cases, so on and so forth. Same power is given here under the PMLA to the survey. They have reason to believe that a person has committed an offense, and they may make any person authorized by that company or the related people who are in management or who know about that to allow them to inspect the records or to verify whether the proceeds of crime or any transaction related to proceeds of crime may have been done, or they may be asked to furnish any information for any manner that may be useful. Now, when the survey is done, survey has no action. They don't have any power to do except gather information in a survey. There is another power of search and seizure given under section 17 and 18, which reads that where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section on the basis of information in his possession has reason to believe that any person has committed an act which constitutes money laundering. Second is in the possession of proceeds of crime involved in money laundering. So the example which I gave today, Ratanji may gave me this money. I might be in possession according to the ED. The searches can be conducted over me. I am in possession of any records relating to money laundering, or I am in possession of any property relating to the crime. And now one may note, this is possession is not proceeds of crime. It reads property related to the crime. Means, for example, I commit a theft at a bank, and assuming for a moment theft is a scheduled offense, I may use my one distant relative may have taken my van, who may have conducted this theft. I may not be aware of this theft. I may not know anything what this has been done, but the ED gets to know that 1 crore rupees has been stolen from the ATM. This Omni car was used. This car becomes a property in relation to the crime. And this car, they trace it back to me. Therefore, I can be liable for a search and seizure. So these are the points on which searches can be done. And when they do a search, they have the power to seize any record which they find during the search, examine any person on oath, make any inventory, place any marks on identification, which is very general like other laws. But what is different is that once your statement is taken here, your statement under section 50 becomes an admissible statement. Unlike a statement under section 132(4) of the Income Tax Act, which without corroboratory material cannot be used, this statement under the PMLA alone today can be used and will be used against you. Therefore, it is very necessary for us to know at the time of search what information to give, what not to give, how to say it, what not to say. And that is where the role of us professionals, us CAs and advocates, and rather I would say this law is something where CAs and advocates together have to work, comes into picture. Then they may freeze any record. Where they're not able to see such record, they may freeze such record. When they want to seize or freeze such record, just like the attachment, they will send that application to the adjudicating authority, who will then adjudicate this retention or seizure as the case may be. Now, I said search under section 17. There is one more section of search under section 18, search of persons. One may ask, what is the difference between these two sections when there is search and seizure and there is search of persons, where also there is power of making seizure? What is the power of making this search? Like I mentioned, that you may not be a person directly involved. A search independently at your premises can also be taken place, where the officer authorized by the central government has reason to believe that any person has secreted about this person or anything about his possession, ownership, control, or records of proceeds of crime, which may be useful or relevant to any proceeding under this act, then he may search that person and seize such record or property which may be useful or be relevant for any proceedings under this act. This may also very well apply to professionals who may have undertaken certain transactions or been a part. For example, a CA who authorizes the audit or audits books for a company now has certain obligations. If he fails to meet those obligations, or even otherwise than that, if they feel that that person has knowledge, then that specific person can also be brought within the ambit of a search, and he may be made subject to this search under the act. Now, sir, these are the civil actions: attachment, search, and seizure. What happens when a search action, a search seizure is taken forward? When a search action is taken or any attachment is made, the adjudication is to be done by an authority which is appointed under section 6 of this act, PMLA, which is called the adjudicatory authority, to whom the complaint under section 5(5) has been filed. Now, this adjudicating authority, upon receipt of a complaint under section 5(5), which is for attachment, or application made under 17(4), which is for seizure, or under section 18(10) for freezing or seizure, is made if the adjudicating authority has reason to believe that a person has committed an offense under section 3 or is in possession of proceeds of crime. He may then serve a notice asking that person to indicate sources of his income, earning or asset out of which the person has acquired the property attached under subsection 1, or seized or frozen under section 17 or 18, and the evidence on which a person relies. Now, if a property is attached which may be held by joint persons, but the case is only against one, the notice is also to be issued to the other person in light of the principles of natural justice. Then, after you make your reply, the adjudicating authority shall, after considering the reply, if any, notice may be and the notice issued under one, and the hearing, and after hearing the agreed party, may make an order. May make an order as to the fact whether the property is attached in money laundering should be liable to be, attachment is liable to be confirmed, or it is to be revoked. However, in 99.99% cases, the adjudicating authority today, only as a stamping authority, stamps and confirms the attachment. I have undertaken over 60 cases 60 cases of attachment, freezing, so on and so forth before the adjudicating authority. And at that stage, our only and only objective is to put forth all documents which we may be able to use tomorrow before the tribunal or before the higher forum. Now, sir, when the adjudicatory authority decides under Section 2 that the property is involved in money laundering, they may confirm the attachment under subsection 5(1) or which is seized under Section 17(18) and up till a period of 365 days. When that property is confirmed, now the draconian power comes that when the property is confirmed, when the attachment of such property is confirmed, the director authorized shall forthwith take the possession of the property. Now, sir, imagine today you or your client is anybody is a property has been attached, you get a notice, the matter goes to adjudicatory authority. Within 6 months, the proceedings are culminated, which most likely will be culminated into a confirmatory order. As soon as the order is confirmed, ED has the power to take possession of your assets. Therefore, it is necessary that in a case where confirmation is made, a person approaches the appellate tribunal first and foremost and applies for a stay so that even if any action is taken by the ED, our rights are secure and we can approach the Honorable High Court by way of a writ petition or use our other remedies available in law so as to protect our interests. Sir, if we read this section 8, section 8(1) is of adjudication of the adjudicatory authority, of the adjudicating authority. If we read it from clauses 8(1) to 8(4), it is relating to the adjudicating authority. But if we read it after section 5 to section 8, subsection 5 to subsection 8, you will see that the powers are mixed. And that is why today we also see that the adjudicating authority today in practicalities asks us, or even it has happened, that the officer sitting there tell us, sir, how can we release this property, sir? This power is only available to the special court. However, that cannot be the intent of the law, and that is definitely not the intent of the law, because the special court does have a power of confiscation, but attachment and its confirmation is to be seen independently by the body which has been granted the right to see that, sir. Now, if we read subsection 5, it says, where on a conclusion of a trial of an offense under this act, क्रिमिनल कोर्ट का जो ट्रायल होता है वो स्पेशल कोर्ट में होता है इनका. The special court finds that the offense of money laundering has been committed, it shall order that the property so involved in money laundering or which has been used in the commission of offense of money laundering shall stand confiscated to the central government. 6. Where on conclusion of a trial under this act, the special court finds that the offense of money laundering has not taken place or the property is not involved in money laundering, it shall release the property. Where the trial of the act cannot be conducted by the death of the person, then they also have to pass appropriate orders regarding confiscation or release of the property. Where the property stands confiscated, the special court may also direct the special central government to restore such confiscated property to the person who has a legitimate interest in the property, who may have suffered a quantifiable loss. Now, this section, subsection 8(8), sir, if you see, the joint reading of this with other provisions is, I feel, the saving grace for all defense counsels, which shows the intent of the law. And this argument also we're taking before lot many high courts and also are getting a favorable decision from that legitimate properties cannot be attached. So, sir, in a lot of cases, I believe the onus will always be on us, and in law also the onus or the burden of proof is on us to prove that the property is not attached. However, if it is a legitimate property, then the duty is on us and we should be able to show and distinguish Our role for our clients is to distinguish that such property which is attached is not a part of proceeds of crime, or our client is all willing to cooperate, and is he fully cooperating during investigation. And you should try during investigation that the attachment is not made and the person is not arrested. If the person doesn't get arrested after getting summons, make be it is a very very well victory for any person to under PMLA to be able to not make his client get arrested, because 90% if you get summons, there will be some form of action in the form of attachment, or in the form of arrest or seizure or search on you, which would take place. And if you have been able to not make it lead to that position, you should be very well satisfied with yourself. Now, what happens? Where is the burden of proof? The burden of proof under the PMLA is a reverse burden of proof. Reverse burden of proof means that in general, ordinary parlance, in general principles of law, a person who alleges a wrong against someone has to prove that that person has committed that wrong. So the burden of proof in general legal parlance is on the person who alleges. However, under the PMLA, if we see section 24 specifically, there is a reverse burden of proof which says that any person who is charged with the offense of money laundering under section 3, the court or authority shall, unless the contrary is proved, presume that the proceeds of crime are involved in money laundering. Now they shall presume what? That the proceeds of crime are involved in money laundering. So proceeds of crime, they presume any other second property, which they take as your proceeds of crime. Now they're going to assume this also to be involved in money laundering by using section 24. That is the depth or the draconian power of the PMLA. Clause B says, in the case of any other person, the authority of court may presume that such proceeds of crime are involved in money laundering. So clause A is a person who is charged with the offense of money laundering. There a presumption, a negative reverse presumption may be taken. And the second clause is in case of any other person, the reverse burden of proof may apply. Now, sir, what happens when your property is attached or the seizure is made or a confiscation is done and which has been confirmed? When such an action is confirmed, one party has the power of appealing to the appellate authority, appellate tribunal, where your appeal lies. Your appeal has to be filed within a period of 45 days. And the tribunal will then hear your question of whether the attachment could have been made, whether the seizure could have been done, whether freezing of your asset could have been done, so on and so forth. So the civil action taken against you under the act by the ED first goes to the adjudicating authority, and thereafter the appeal. Only the first appeal which is available before you is to the appellate tribunal. So this is the realm of your civil proceedings. What happens in criminal proceedings? In criminal proceedings, sir, there are probably 10 or 15 trials which have concluded since 2005, as I mentioned. So ED is filing complaints, and that case will go on and go on and go on till ages to come, till I also might lose my hair or my hair might become silver gray. But what we see today is the action of arrest under the PMLA. And what makes this law draconian is that the threshold of bail under a PMLA provision is so high that a person has to prove to the court, not just prove to the court, has to satisfy the court that there are reasonable grounds to believe that that person is not guilty of the offense of money laundering. So, sir, I ask myself this one question at this juncture, that when I have to prove that I'm not guilty at the time of bail, why are we conducting this trial in the first place, sir? And isn't this condition too onerous on a person that he has to prove that he is not guilty? Because till that time, when a person is arrested, a lot many times, maybe an attachment is also not made. Maybe no action is taken. Maybe a complaint is also not filed under the PMLA. But then how can he prove? His documents would not be provided to him. The documents which the ED has will not be provided to you till quite an extent. Or whatever is available to you will only be what the ED is trying to say. That there is a scam of 5,000 crores, there is a scam of 10,000 crores, and it changes the demography of the entire country and the entire country's economy, and henceforth the bail should be denied. That is what they say. That is what the ED prosecutors come today. I ask myself how difficult and onerous this condition would be. And I read section 5 now. Notwithstanding anything contained in the CRPC. मतलब सीआरपीसी में जो भी लिखा गया है उसको बिना नजरअंदाज करते हुए नजरअंदाज अब क्या करेंगे? बेल प्रोविजन सेक्शन 438 439 सीआरपीसी. No persons accused of the offense under this act shall be released on bail on his or on his own bond unless. Before coming to the underpoints, one may see that how negatively worded this section is. No person accused of an offense under this act shall be released on bail unless A, the public prosecutor has been given an opportunity to oppose the application of such release, and 2, where the public prosecutor opposes the application, which officially will obviously he will, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offense and he is not likely to commit any offense while on bail. So, sir, the conditions of bail are extremely tough. That is why we would today see who's who of the society languishing in jail for years and years to come. People like Chidambaram, who made this law today, were also behind bars. People like the owners of Unitech, Mr. Chandras, they are behind bars. Manish Sisodia, Sanjay Jain, Praveer Raut, Sanjay Raut, all these people today or at a point of time were for a good duration in custody for a simple reason of section 45 and the threshold which it holds. Now, sir, at that time, during your trial or during your bail, what would be read to you is, what would be shown to you is, I think, very less documentary material, but statements of people. Statements of persons who I, statements of person who would show that, statements of persons who would show that or been taken under coercion, taken under fraud, taken under any circumstances, which we all can imagine under the circumstances under which such statements are taken or recorded. Those statements are only used against you that time because those statements have evidentiary value under the act. that statements are on oath, that statements have scientific value, and in your bail proceedings, in your attachment proceedings, so on and so forth, they will be used. So with this, I would end my brief overview on the PMLA as to what is the PMLA and what is the brief overview of the proceedings under the PMLA. Having said this, it was also requested at the initiation of the seminar that CAs today, what can be our opportunities? How can we use this law in our profession? How can we help our clients professionally? I will come to that in a while. It was also asked as to what are our obligations, because in May, June, there was a havoc created by this notification of 3rd May 2023, which said that CS, CSs, and CWAs are now brought within the ambit of the PMLA. And let me make it clear, nobody has bought within the ambit of PMLA. PMLA is neutral to all. This notification which was enacted, or which was notified on the 3rd of May 2023, only brings out certain obligations on chartered accountants, company secretaries, and cost and works accountants, who, when these professionals work or act on behalf of their clients in the course of his or her profession in relation to the activities of buying and selling of immovable property, or managing clients' monies, securities, or shares, management of bank or savings accounts of the client, organization of contribution for creation, operation, or management of companies, creation, operation, or management of companies or LLPs of the company, and buying and selling of business entities. These activities are not directly attributable to the direct professional working of a CACS or CWA. Buying and selling of an immovable property is not the role of a CA or a CS or a CWA. Managing clients' money, security, or assets is not the role of a CA, CWS, or CWA. Likewise, managing bank accounts or organization of contribution for creation, operation, or management of companies, or buying or selling of business entities is not a activity of a CA, CWS, or a CW, or a CS or CWA. These are ancillary activities which we might take in the course of our profession. When there is such an activity, then we have to report such activities where we feel to the FIU, so that proper reporting and proper investigation, if required, can be done. And only on those conditions can a CA, CWS, CWA been bought within the ambit of PMLA. And rather, not even bought within the ambit of PMLA, they would be only reporting entities. And I stick abide by my term. I've also had the good fortune of representing NAFRA, National Financial Reporting Authority, which takes actions against the CAs in debarring them. CAs of public listed companies and big private institutions having turnover of 1,000 crores. Sir, I still believe that CAs are the backbone of our economy. However, unfortunately, today, if we see these big scans, at the same time, we will also be unfortunately and undoubtedly say that yes, certain professionals have also partaken into that activity coming into picture, or that crime taking place, or that money going withering away. Money from public banks, which affects people at large. And that is why rather the PMLA or the ED officials have come and they have made this only as a reporting entity and rather a clause for redemption of CAs with the great name, so that first the economy can be protected and the great name of this great profession of a CA can be protected and upheld. So, sir, with this, I would go to my last segment, which I will take 5 more minutes for that. What are the professional opportunities which come for CAs, and how can we take forward, how can CAs benefit professionally from this? Sir, when any attachment is made or any summons are received by any of our clients, I, sir, can say that I am thankful to the CAs, though I have a tax background, but CAs are doctors of numbers, I will say. जितना अच्छा नंबर्स के साथ समझा सकता है CAs को, no lawyer can understand that. No advocate having even experience of 200 income tax cases can understand, I will say. And ये मैं अपने लिए बोल रहा हूं कि I feel, so that is where the role comes, that when there is a case, a CA after reading it will be able to say, sir, this is what it is. सर यहाँ बुक्स ऐसे हुई हुई हैं, सर यहाँ सिर्फ एक जर्नल एंट्री पास की हुई है हमने, सर यहाँ इन्होंने इंटरेस्ट ले लिया हमने, इंटरेस्ट की हम लोग जर्नल एंट्री पास कर रहे हैं, ना कोई लोन रिपेमेंट हुआ है ना कुछ हुआ है इतने सालों से, बैलेंस शीट में बस लोन हमने दिखाया हुआ है. As a lawyer, he would just see, sir, we've shown this is a loan. But a CA would can go in depth in this and see that this loan has been standing there for the past 10 years. No interest payment has been made. No repayment has been done. And sir, therefore, this loan is only in the books and is shown as only in the books. तो साहब इस पे आप इतना हार्प मत करिएगा. तब लॉयर सोचेगा कि हाँ जी, सेक्शन 3 में तो दिस कैन बी शोन टू बी क्लेमिंग इट एज अनटेंटेड प्रॉपर्टी में भी आ सकता है केस, एंड आई मे बी चार्ज्ड विद money laundering. Therefore, I feel that this law of PMLA drives on a synergy of advocates and CAs alike. And we all together have to come together and take it forward. Such is the case with the Black Money Act. Black Money Act is of foreign assets. It's a 2015 legislation. It has been very recently in action since 2018. I have had the good fortune of arguing the only case on merits and getting a relief of 192 crores from the Income Tax Tribunal, Jaipur Tribunal, which was in the case of the ex-chairman of State Bank of India. Likewise, I cannot disregard or give less credit to the CAs who assisted. And likewise in PMLA, I would say it is a synergy of work. With that, I hope I could briefly explain the provisions of this law, because इस law के लिए तो 3-4 घंटे भी अगर मैं बोलूं बहुत कम है. How it goes, the interplay between two sections itself, section 3, section 21U, section 5 and section 8 alone can go on for hours and hours and hours. But I again Asli would like to thank each and all for giving me this opportunity, for allowing me to speak on this topic. Thank you.
Thank you so much, Sankalp ji, for giving an eye-opening, really an eye-opening deliberations on the subject PMLA. And we are honored, basically we are honored by your gracious presence and valuable presence. We are grateful towards you for sharing your views and showing your concerns to our profession and professionals. We are really, really grateful towards you, sir. Now, is there any query from the participants? There are few queries. I think there are one or two queries.
Yes, sir.
One query is how you define crime. What is the crime?
Sir, crime in PMLA is of the scheduled offense. Crime in PMLA are the crimes which are given under the schedule, which is this. So, for example, you commit a crime under 420, which is cheating. 420 is cheating. So you cheat the bank. You have no intention to repay the bank. You become NPA. That is a case of cheating. And cheating in this case would become your crime.
Crime under PMLA.
Crime under PMLA. And the money generated out of this crime is your proceeds of crime, and proceeds of crime is the subject matter of PMLA.
So if you don't pay, if your account goes NPL, if you are not being paid to banks, then you are under PMLA. You are also under
Yes.
PMLA.
Yes, sir.
Very good.
Only in the case when cheating is there, na?
Yes, in cases where
cheating is there.
Yes, sir. In all the cases, I'm even seeing cases where
Department can make the case of cheating.
not in each and every case where there is an FIR filed of cheating or cheating by person, or there is a case of PC Act, Prevention of Corruption Act, where they charge you along with the officials of the bank. जैसे सर हम बहुत सारे केसेस सुनते हैं कि किसी कंपनी के पास क्रेडिट वर्दीनेस नहीं थी इतनी जितना उनको लोन मिल गया. तो लोन कैसे मिलता है साहब? लोन ऐसे ही मिलता है when we speak with a lot of my friends, seniors and colleagues would also be working in financing. So we would know in what manner are loans granted from the bank. And when we go for big loans, let's say of 50 crores, 100 crores, 150 crores, 200 crores, 500 crores, 1000 crores, in those scenarios, there obviously, and you don't have any credit worthiness, an FIR would be lodged against the company, against the officials of the bank, stating that they in connivance have cheated the bank and have gone ahead with it. With that FIR, PMLA will come into picture and ECIR would be recorded, and ECIR then your PMLA, your attachment under PMLA, your so on and so forth would go on. And under PMLA, what would be seen is जो आपने पैसा चुराया बैंक से, जो पैसे की आपको बढ़ावत हुई है, that is the proceeds of crime. That will be seen, attached and confiscated.
सर ये प्रोसीड ऑफ क्राइम और
जी सर.
ब्लैक मनी में क्या डिफरेंस है? ब्लैक मनी को अगर व्हाइट में कन्वर्ट किया तो?
सर ब्लैक मनी क्या होता है? ब्लैक मनी इज योर अनअकाउंटेड मनी. सर इसका आंसर भी लॉ में ही दिया गया है. जो पीएमएलए का शेड्यूल है, पीएमएलए के शेड्यूल में इनकम टैक्स एक्ट इज नॉट अ शेड्यूल्ड ऑफेंस. तो मतलब अगर आप टैक्स चोरी करते हैं, मैंने जी ब्लैक में काम करा, मैंने कोई क्लाइंट से कैश में काम करा, तो वो कोई शेड्यूल्ड ऑफेंस नहीं बना, वो कोई क्राइम नहीं हुआ एज फार एज पीएमएल इज कंसर्न.
ब्लैक मनी को व्हाइट किया तो?
ब्लैक में व्हाइट करा सर, 68 का आपका एडिशन बनेगा, सेक्शन 68 का अनएक्सप्लेन कैश डिपॉजिट का अंडर द इनकम टैक्स एक्ट, अंडर द पीएमएल देयर इज नथिंग, बिकॉज शेड्यूल्ड ऑफेंस ही नहीं हुआ आपका.
नहीं संकल्प, अगर ब्लैक मनी फ्रॉम बिजनेस ओनली, देन यू आई थिंक राइट. अगर ब्लैक मनी का तरीका कमाने का कोई अपराध है, आपका क्राइम है जो कि शेड्यूल्ड ऑफेंस है, देन थिंग्स विल बी डिफरेंट, राइट?
वो तो चीटिंग हो गया. वो तो ये चीटिंग कि मान लीजिए मैं अपने बिजनेस में आज लेट से मेरा कंस्ट्रक्शन का बिजनेस है, कहता हूँ कि जी 1 साल में आपको पोजेशन दे दूंगा. मेरे को पता है मैं 10 साल तक आपको पोजेशन नहीं दे सकता। मेरे को पता है कि मेरा जो ग्रेटर
मेरा भाषण और
का स्टेक है इस पे, क्या कहते हैं पे, वो ग्रेटर नोएडा अथॉरिटी का मेरे को पैसा देना है तब मेरे नाम पे प्रॉपर्टी आएगी, उसके बाद मैं किसी को दे पाऊंगा। लेकिन मैंने किसी से पैसा ले लिया कि मैं आपको 1 साल में दे दूंगा, दैट इज चीटिंग, दैट फॉर्म्स अ क्राइम। वो मैं अपने बिजनेस एक्टिविटी में अगर ऐसी चीटिंग करूं और मैंने शेड्यूल्ड ऑफेंस, जो मैं ऐसी चीट जो मैं चीज कर रहा हूं, दैट फॉर्म्स अ शेड्यूल्ड ऑफेंस। तो जो मैंने उस क्राइम से पैसा कमाया है, जो प्रोसीड्स ऑफ, तब वो कैरेक्टर लेंगे प्रोसीड्स ऑफ क्राइम का, तब पीएमएलए आएगा। बट अगर ब्लैक मनी को वाइट किया तो आपका नहीं होएगा।
उसमें अगर हवाला किया तो
सर हवाला
प्रोसीड ऑफ क्राइम में आएगा क्या?
नहीं, हवाला भी आपका फेमा, वो फेमा में आता है, फॉरेन एक्सचेंज मैनेजमेंट में आता है। फॉरेन
हाँ।
एक्सचेंज एक्ट आपका इज नॉट अ शेड्यूल्ड ऑफेंस। Rather, Foreign Exchange Management Act is regulated by the ED itself. So ED दो लॉज के अंदर काम करता है, फेमा और आपका पीएमएलए।
अच्छा,
तो हवाला एक्शन आपका आएगा फेमा के अंदर सर।
तो ये प्रोसीड ऑफ क्राइम में चीटिंग से रिलेटेड है ये?
हाँ सर, भाड़ ले जाना सिर्फ फेमा है, लेकिन आप बैंक से चोरी करी, जो ने एनपीए कर लिया, वो तो आपको प्रोसीड्स ऑफ क्राइम बन गया ना साहब। तो फेमा गए, भाड़ ले जाना वाला सिर्फ एक ट्रांजैक्शन है, उससे पहले ट्रांजैक्शन बैंक से चीटिंग करना, फिर बाहर पैसे को रूट करना, पैसे को कुछ और बनाना, ये पूरी चीज पीएमएलए है।
नहीं, अपना ही पैसा बाहर ले गए, अपन हवाला करके ले गए, तो उसमें कहाँ क्राइम थोड़ी हुआ?
नहीं, वो सिर्फ फेमा बनेगा
एमएलए में
आपका,
नहीं
वो
आएगा।
सिर्फ दैट विल ओनली बी फेमा। बट अगर आप चीट के पैसा बाहर ले जाते हैं, शेड्यूल्ड के कोई पैसा बाहर ले जाते हैं, दैट विल पीएमएलए।
शंकर जी, हमने वर्ड यूज किया था आपने नोइंगली। If I am unknown that my client is giving me 1 lakh of rupees as a fees, but the money is from the earned by client from the criminal activities. So I may be concerned with that.
Sir,
I am not knowing. I am unknown about the criminal activities of my client.
Absolutely, sir. And it's a very, very good question. This question is being faced all across. Right now, it is pending adjudication in a lot of courts. But, sir, I believe, and my opinion, in my limited opinion, I say that your bona fide transaction cannot be bought within the ambit of PMLA when you're a third person. You may have a reverse burden of proof under section 24, which I just read. That reverse burden of proof is also rebuttable. You today cannot go into the coffers of a person to analyze whether वो साफ है या वो साफ नहीं है। और आप पूछ के भी अगर करेंगे तो आप तब भी गारंटी नहीं दे सकते कि या वो साफ है या नहीं साफ है। तो साहब, हमारा ड्यूटी क्या होनी चाहिए इन सच सिनेरियोज इज टू शो व्हाट वाज आवर ट्रांजैक्शन। And in a lot of cases, sir, I can tell you, in a case of Unitech cheated its home buyers. Unitech के ऊपर केस आया कि जी यूनिटेक ने होम बायर्स का पैसा लेके भाग गए, 14,270 करोड़ उन्होंने लिए। इसमें से 14,270 करोड़ में से उन्होंने 5,000 करोड़ का क्राइम किया, प्रोसीड्स ऑफ क्राइम बन गए। एंड just a second, sir. Just a second, sir.
Yes, sir.
तो प्रोसीड्स ऑफ क्राइम बन गए। यूनिटेक then invested in another project which was a slum rehabilitation project in Bombay, जो एक्चुअल कंस्ट्रक्शन हो रही है। और उस कंस्ट्रक्शन में उन्होंने एक एसपीवी में 50% शेयर ले लिया फॉर 1,000 करोड़। साहब, पूरा एसआरए का प्रोजेक्ट जो बॉम्बे में आप जानते होंगे BKC है, बांद्रा कुर्ला कॉम्प्लेक्स, which is a very very prominent location in Bombay. 100 acres in Bombay have been attached. Ab saab, what my client is making that slums, they're doing that construction. It is a genuine business activity which they are doing. How can you not today attach my property? So, sir, we are fighting this case tooth and nail by saying, sir, that even if you could attach, you could only attach those shares limiting to that 50%. जो उन्होंने 500 करोड़ दे के शेयर्स कमाए, इस SPV में शेयर्स लाए हैं अपने, वो शेयर्स आप अटैच कर सकते हैं। मेरा जो आपने एम्बिट मेरा अथॉरिटी का आपने ये कर लिया है, जो मैं स्लम रिहैबिलिटेशन प्रोजेक्ट कर रहा हूँ, जिसमें मेरा नहीं, एक स्लम रिहैबिलिटेशन अथॉरिटी विच इज अ स्टैट्यूटरी अथॉरिटी, उनका राइट है, स्लम ड्वेलर्स का राइट है, उनका आप राइट लेके जा रहे हैं। Now, sir, those things are to be kept in mind, and we need to show that our transaction was an arm's length transaction. But, sir, to answer your question and coming back to the point of knowingly, sir, knowingly के साथ भी लिखा है knowingly or unknowingly, directly or indirectly. If you see,
Unknowingly नहीं है sir, word only knowingly is there, directly indirectly is there.
Directly or indirectly, knowingly assist or knowingly is a party.
Yes.
Knowing is a party to any proceeding or process relating to the proceeds of crime.
Yes.
Now, sir, any activity relating to the proceeds of crime is what? Also includes possession of proceeds of crime. Agreed?
Agreed.
ठीक है? So now, even if you're indirectly related to only possessing proceeds of crime, आप बताइए साहब।
My question is that how do I know कि ये proceeds उसकी crime से है या नहीं है? This is my question only, simple, very simple. मैंने banking transaction से पैसा लिया, मैंने proper services दी, मैंने proper bill raise किया, and that again I got the money. It may be from the criminal activity, earned by criminal activity by my client, but I'm not really knowing his business. I just gave my services.
Correct.
I honestly I gave services, and honestly I received the check. I bank it check.
सर
Yes.
आपकी सर्विस छोड़ दो, मलिक जी
Sir.
की जो है वही ले लो, मलिक जी केस लड़ेंगे, उसका वो फीस लेंगे, उसके लिए बात कर लो, ज्यादा बेटर समझा पाएंगे।
हाँ हाँ, एक ही बात है सर, वो तो एक ही बात है।
नहीं, अब बेटर समझा पाएंगे सर। ये
इसमें सर ऑडिटर का एग्जांपल ले ले तो बेस्ट होगा।
सर प्रोफेशनल I would say
प्रोफेशनल एक ही है।
Auditor might be knowing the facts of the business.
Yes.
But apart from the audit, I am giving the consultancy services, जहां मेरे को बहुत ज्यादा उसके सपोज ओपिनियन ही मैंने फ्रेम किया, सपोज आई फ्रेम एन ओपिनियन, रिक्वेस्टेड ओपिनियन मैंने फ्रेम किया और वो उनको दे दिया, एंड आई गेट द कंसल्टेंसी फीस, बट द फीस वाज अर्न्ड बाय द क्लाइंट फ्रॉम द क्रिमिनल एक्टिविटीज. हाउ कैन आई नो इट? So my fault is not, but I may be.
इस सवाल को रतन भाई सवाल को और बेटर बनाते संकल्प भाई।
सर बताओ ना आप, यू आर द एक्सपर्ट ऑन दिस।
संकल्प भाई, PMLA का क्लाइंट आया जो PMLA के बाद से पीड़ित है, उसने आपको फीस दी, आप तो ये मानो PMLA उस पर लग चुका, उसका शेड्यूल्ड ऑफेंसिव क्राइम मनी है, उसने उसमें से आपको फीस दी, तो व्हाट इज द कोर्स ऑफ एक्शन ऑफ द डिपार्टमेंट अगेंस्ट यू?
सर सीएस और पे प्रोफेशनल्स पे ये इम्पैक्ट नहीं करेगा। पहले आप बिजनेस ट्रांजैक्शन का एग्जांपल ले लेता हूँ यही, ठीक है? प्रोफेशनल्स पे दिस विल नॉट बी एप्लीकेबल। अभी एक केस गया भी था, देयर वाज वन सीनियर एडवोकेट जिनके अगेंस्ट ऐसी एक्शन ले लिया, द मैटर वेंट टू द सुप्रीम कोर्ट डायरेक्टली, एंड तो प्रोफेशनल से केस में इट विल नॉट बी एप्लीकेबल, लॉन्ग इन शॉर्ट। बट इन अ केस ऑफ बिजनेस, सर व्हाट वी नीड टू शो इज कि नोइंग अननोइंगली हम लोग नहीं प्रूव कर सकते। वो बोलेंगे कि आपको नोइंगली है, हम बोलेंगे अननोइंगली है, तो किसकी बात मानी जाए? और सेक्शन 24 में आपके पास रिवर्स बर्डन ऑफ प्रूफ भी लगता है साहब, तो प्रिज्यूम करा जाएगा कि जी मनी लॉन्ड्रिंग का हिस्सा है। तो हाउ डू यू प्रूव? यू प्रूव कि साहब मैंने एक बोनाफाइड काम किया है, जो मैंने काम किया है वो मैंने एक्चुअली में ही किया है। मैंने इसको जब, अगर इसने मेरे से, एक आदमी ने गाड़ी खरीदी मेरे से और एक पैसा दिया 5 लाख रुपए का, बड़ा छोटा सा एग्जांपल लेता हूँ, सेकंड हैंड गाड़ी ही खरीद ली किसी ने, 5 लाख रुपए की गाड़ी खरीदी, मेरे पास 5 लाख रुपए आया। अब साहब मैंने गाड़ी बेची ना, वो 5 लाख रुपए के फॉर्म में योर आर्गुमेंट शुड बी कि वो गाड़ी हैज बिकम द फॉर्म, पीओसी का नेचर चेंज हो गया है इन द फॉर्म ऑफ दैट कार टुडे सर। जो मेरे पास पैसा आया है दैट इज नॉट पीओसी एनी मोर। I have earned something from a genuine business transaction, from a
Right.
genuine transaction which is nowhere related to proceeds of crime or related to the scheduled offense.
Absolutely.
My activity is nowhere in relation to scheduled offense. So my activity, my money generation cannot be called to be proceeds of crime. And when there is no proceeds of crime, I or no action can be taken against me, sir.
Good, sir.
And after that, I will come and show that the section is worded knowingly attempts to indulge or knowingly assist or knowingly is a party or such and such, that the intention of the provision is blah, 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 blah. So that would be my intention. Now, sir, a lot of water. I'll take one moment,
Yes, sir.
2 minutes lastly, if there are no more questions. If there are more questions, please, sir. In case there are no more questions, or in the meanwhile, I will just enshrine that there are a lot of, जैसे police, ED is not police officer, therefore the statement given to them is valid. ED does not have to give you an arrest, they can arrest you at the same time. ECIR is not to be given to you, it is not a public document. These are some things which have been enshrined in a lot of cases which led to the Supreme Court. And last year, a judgment came out by the Honorable Supreme Court in the case of Vijay Madanlal Chaudhary versus Union of India. So, in Union of India versus Vijay Madanlal Chaudhary, it was decided that police officers are not, that ED officers are not police officers. They do not have to give you the material. They do not have to share the ECIR with you. They do not need to tell you whether you're an accused or a suspect. When you're not an accused or a suspect, your fundamental right under Article 20, subclause 1, which is of self-incrimination, does not kick into play. जैसे सर क्रिमिनल केस में सेल्फ इंक्रिमिनेशन का हमारे पास प्रोटेक्शन है अंडर आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन, कि अगर हमसे पूछे कोई आके पुलिस तुमने चोरी की, हम चुप रह सकते हैं। और हमने अगर पुलिस वाले को बोल भी दिया कि नहीं साहब मैंने चोरी करी है, उस स्टेटमेंट की कोई वैल्यू ही नहीं है अंडर सेक्शन 25 ऑफ द एविडेंस एक्ट। वैल्यू किस चीज की होएगी? पुलिस मेरे को मार मार के चुपता, आप गए, चोरी आपने किस गाड़ी में करी, ये गाड़ी किसकी थी, ये गाड़ी कहाँ छोड़ी, ये आपने वहां पे कैसे करा, वो जो डिस्कवरी होएगी, डिस्कवरी अंडर सेक्शन इन अ नॉर्मल क्रिमिनल केस, इन अ ईडी केस में हम एक राहत मिली है केस की, राहत जिसको मैं बोलूं, मैंने कहा गंगोत्री इज शेड्यूल्ड ऑफेंस साहब, गंगोत्री पीएमएलए की, आई रिपीट, is your scheduled offense, is your crime. So with that,
Thank you, brother. Thanks a lot, Sankalp bhai. Now I would request Amit Agarwal ji, secretary, for the formal vote of thanks. Amit bhai. Amit Agarwal ji.
हेलो,
Yes, please.
नमस्कार एवरीवन। सबसे पहले संकल्प जी का संकल्प से कि इन्होंने के साथ डिटेल में अंडरस्टैंडेबल लैंग्वेज में और एग्जांपल्स के साथ जो हमको पीएमएलए प्रोविजंस एंड अपॉर्चुनिटी फॉर द प्रोफेशन के बारे में समझाया है, वो बहुत ही जोरदार और गजब था। उससे भी बड़ा एक धन्यवाद मैं देना चाहूंगा सतीश जी भाई साहब को। एडवोकेट विनय जोशी साहब प्रेसिडेंट RTCA, रतन जी साहब और मनीष जी की इतने जोरदार डायमंड और कोहिनूर स्पीकर आप ढूंढ कैसे लेते हो?